Good afternoon or morning, everybody, depending on the time zone that you are joining us from. Again, my name is Eric Bowman. I'm very happy to join you today. A few months ago, I was going to do this seminar. This was in mid to late in fall of last year, and I put together all of the materials. And I have to say, since we got delayed and for reasons other client commitments, I had to postpone. And now I'm doing it here in early 2026, and a lot has changed. I realized over the weekend I better look and see what kind of developments have been going on. And I generally follow this material, uh, but wow, have there been a lot of developments? Proposed federal law that's in the pipeline, lots of state law, lots of development, and then I base this generally back on the where I started, which was back in 2019. I was part of a group who authored, as far as I know, the first book on law and artificial intelligence. I have a copy right here, actually. It's the ABA's Law of Artificial Intelligence and Smart Machines. And wow, has a lot changed in the last few years since I wrote that book. I made some predictions there, well, I didn't write the whole book, but I wrote a chapter on AI. It was intelligent eavesdropping. By the way, I dropped that chapter. We dropped that into the chat. There's a summary of it and the chapter itself, if you'd like to read it. And you can see where I got some issues correct and where I missed on some of my predictions. What we're finding today is that AI is prevalent everywhere, but it's really embedded deeply in healthcare operations. And so for today, the goal here isn't a technical deep dive, but I'm going to give you a legal and regulatory overview of what providers need to know right now and what you need to be aware of, what you need to expect as we move forward into what is really becoming a brave new world of artificial intelligence. Uh, by the way, some terms, I didn't put these in the slides, but some terms that you may hear just when you're hearing about AI. There was machine learning. And when we go back several years, you have machine learning, and then you had large language models, which was AI essentially, or data essentially being aggregated by machines and summarizing it and making conclusions and predictions based on the data that was provided. Then we moved into generative AI, chat, GPT, and things of that nature that will actually produce new material based on things that it learns. And now we've moved into another world of agentic AI. You'll hear that term sometimes. And that's where the AI will act, I suppose I'd say semi-autonomously. You can give an agent instructions, an AI agent instructions to go off and perform tasks on its own. And I suppose the next step is autonomous AI, and we'll see, how long it takes to get there, and if we do get there. All of that does overlap with what we're talking about in healthcare, because the overriding concept that you're going to see throughout today and in this area is the balance between the AI performance and the human performance of the human provider. As I was talking to an esteemed colleague who knows a lot more about artificial intelligence and computers than I do, he made the analogy of sort of keeping your hand on the controls. I think it was Neil Armstrong. And he said, there's always going to have to be a human involved, or at least for now, a human involved to put their hand on the controls if the AI can do most of it, but if it starts to pilot into a crater or make a wrong move, the human needs to be there to correct it. Well, that raises some interesting ideas and thoughts. Is it one, are humans, is one human or are humans good enough to be in a situation where the AI gets it right 99 times in a row, but then on the 100th time it misses? That takes a lot of awareness and a lot of ability to stay alert for the human who's in charge. And then there's this other concept that when the AI gets so good that it performs tasks or analysis better than an individual human, if there's a human involved and the human is the safeguard, does the human start to get in the way? I don't have the answers to those questions, but they are interesting questions to think about as we go forward. What I'm going to touch on today are legal and regulatory issues, but I'm going to step back before I do that and go back to, again, 2019 when I authored this AI topic. And some things that I got right and some things that I got wrong, as I mentioned earlier. One, AI is fundamentally about data. And I had said that from the beginning, that who owns the data, who controls the data, how data is used and shared. From a legal perspective, and when lawyers are looking at contracts, that's one of the biggest issues that I'm looking at for clients when we're dealing with vendors and anybody who may have access to your information. What are you going to do with the information? And I represent some companies who one electronic medical records company, another company that does billing, and so they have access to a lot of data. The question is, what do you do with that data? How can you anonymize it and use it for training? Is your data as a healthcare provider, are your vendors using data for training? That's a big question that we're going to want to know the answer to before you get into business with somebody in who's handling your records and data. So I did get that right. I knew that at the time, it's all about data. What I got wrong is I had assumed at the time that the biggest threat would be government surveillance. I don't put that aside. Lots of has been going on in the news over the last couple of years to call into question, what level of surveillance the government engages in. That's not the topic for today's discussion. It is an interesting topic, and I could get on a soapbox. I'm not going to do that. But that was sort of what I thought would be the big issue would be government surveillance. I had talked about some Supreme Court cases at the time. To what extent can law enforcement look into your phone and tap into devices that are readily available? What actually has happened is that private companies have really become the biggest collectors and users of personal data, and and we're seeing that consumers, including patients, voluntarily provide enormous amounts of information to to private companies. And so the real privacy revolution out of all this came from us handing data over ourselves to private companies and to government. And individuals face a bit of a Hobson's choice when it comes to what to do with your own information and how to protect it, because a lot of the beneficial aspects of AI, a lot of beneficial apps, a lot of the apps that we use now for to assist medical healthcare providers, even in health apps, going back to early days of the Fitbit and everything else, there's to some degree you have to give up control of your data in order for that to work. And if you want to take advantage of those benefits, you have to be willing to give up some level of control and some level of autonomy over your own personal data. So there's always a balance there. So that's an issue that we've always seen with AI, and I don't think it's going to get any simpler. The bigger questions now are the rights and responsibilities of providers as this continues to develop. So that's what we're going to dig into. So this is interesting. I wanted to talk about this case, and I talked about this a few years ago in in the original writing that I did. It was an early example of technology becoming legal evidence in this in connection with a pacemaker. And this was an Ohio arson case where a man claimed he had escaped from a burning house while carrying some heavy items out of the house. And investigators were able to obtain his pacemaker data, and they got a cardiologist to look at this data. And the cardiologist testified uh, that the data did not line up with his story, that his heart uh, rhythms and heart patterns and pulse and so forth were not aligned with the story that he told, that he woke up in the middle of the night and he started to that he was able to get out of the house at the last minute. The big question in the case, probably not so much a surprise now that you could see that you could essentially retrace someone's steps physiologically, at least from a heart condition, from getting pacemaker data after the fact. But the big legal issue here was that data admissible in court? And this is what jumped out at me at the time, was that when the judge admitted the data in the original hearing in this Ohio case, the judge said, "Yeah, I don't see what the big deal is. It's not that big a deal." And that stuck with me at the time. It was the first time, as I'm aware of, and maybe that was a 2018 case, when a medical implant device testified against the owner of the device. There's some other examples that I talk about in the book chapter with a Fitbit murder case where a boyfriend or romantic partner of an individual was charged with murder based on Fitbit data that contradicted the story that he gave law enforcement. There's a couple other examples. I'm sure there have been more along the way. The first one that was known, that made national media attention, was an Amazon case where Amazon's Alexa data was subpoenaed by law enforcement in Arkansas case in connection with the murder allegations. That kicked off a whole stream of questions about the legal admissibility, the ability of companies, what was the ability of companies to protect that data and the requirements to give it up to law enforcement. In healthcare, the witness is no longer just a pacemaker. The witness can be an algorithm embedded in a medical record. And so we're seeing this concept expand right before our eyes. So a few years ago, my AI discussions focused on smart devices such as smart speakers, again, the Amazon Alexa, wearables like a Fitbit, Apple devices, and so forth. And today, the technology has moved back to directly into healthcare. And some examples that we see in healthcare systems today are radiology, AI analysis, sepsis prediction models, ambient AI documentation tools, prior authorization, automation, a lot of controversy around how AI is used in connection with making healthcare decisions, especially the push-pull between the payer and the beneficiary and the provider. I work a lot in that space and see those issues firsthand. Predictive risk scoring, remote patient monitoring. The message for all providers is that again, the witness is no longer embedded simply in the Echo device, it's in the electronic health record. And so the control of that record, access to that record, how it gets protected, your things as simple as your business associate agreements. I'm rewriting those for clients. I've rewritten several of them to account for the handling of data in unique circumstances. All right. So I want to do here's an overview of today's discussion, and I want to poll the audience for a moment here and ask a question. And if we were all live in an audience, I would maybe do a show of hands, and I'd ask you, how many of you believe that AI is already being used in your work organization today? And I get a show of hands, and maybe I don't know, maybe half would raise their hands, and maybe half aren't aware. Uh, so for a moment, play along with me here and keep your hands up. And then I want to ask you if your organization uses any of these items: radiology imaging software, or sepsis prediction alerts, EHR, clinical decision support tools, ambient AI documentation tools, revenue cycle automation, prior authorization review tools, or remote monitoring devices. If your practice uses anything like Epic, Cerner, Athena, or any modern EHR system, you already have AI-driven decision models and support embedded within that system. And so the question isn't whether AI is coming to healthcare, it's already here. And the real question is whether we understand the legal and regulatory and liability implications of the tools that we're already using in our practice. All right, so this is kind of the history here, as I mentioned from early on, the the start of legal review of AI beginning back in 2019, 2018, 2019. I was involved with the American Bar Association technology group that started looking at, hey, this AI is coming on pretty fast. There's issues that are arising, and there's going to be a lot of legal questions around it. How do we address that? My involvement in that started with an article that I collaborated with that was in the American Bar Journal, and then led to this to a seminar in Chicago where we dealt with professor. We had a panel up there that I was a part of, and it was a professor from the University of Chicago that was involved in machine learning, and some folks that were in business using early machine learning models, AI models, what eventually became AI, and then it led to work on this book. And now, we're what, 7 years, we've seen the development where those issues come up regularly in healthcare compliance and liability. We've now moved from the Alexa and the Fitbit to AI diagnostics and predictive analytics, and of course, remote monitoring tools and access to those tools, security functionality, and an access to the data around those tools. Now we've got introduced a new concept that's arisen over the last couple of years, software as a medical device. Many AI diagnostic tools fall into this category. And those tools, if they are considered medical devices, there's now this area of regulatory question marks, I'll call it, with the FDA on whether a tool is considered a medical device, whether it's being relied upon to make diagnoses and medical decisions. And if it is, many of those tools now have to be cleared through FDA. And the FDA is struggling with how to develop rules. We'll talk about that in a few minutes on some of the federal developments on regulatory environment in this area. But the issue with the software as a medical device is this stuff changes over time. And for anybody who has a computer and turns it on, if you go a week without turning on your computer and it needs to make updates, well, these AI systems are constantly being updated and they're constantly they should be being improved. And as they're being improved, the devices change. And so if you get AI devices that are approved by the FDA, is that the same AI device a week later, a month later, a year later? Does it have to go through another round of approvals? And that's an issue that the FDA and other regulatory bodies are dealing with and struggling with. I want to do a little overview of some federal AI developments. And quite candidly, the more developments, we'll talk about this in a few minutes, are at the state level. But what I've come up with from a federal aspect is the beginnings of certain frameworks. The FDA obviously has been dealing with this for a couple of years with implant devices and medical devices. The ACA has now been updated to apply to the Affordable Care Act now applies to clinical algorithms. Um, and this means that hospitals and medical providers have to evaluate AI tools for bias or discriminatory impact. That's the ACA rule. Health IT policies, increases on emphasis in transparency and AI decision-making tools. The issue with bias, we'll talk about in a few minutes. I'll give you an example of that. That's a real legal struggle right now that not only has to be dealt with at the developer level and implementation, but providers have to be aware of those issues so that you can account for those in your decision making when you're using AI to support that decision making. There is, by the way, I mentioned not much in federal law development. There is, President Trump's administration has announced an AI development of an AI framework, but nothing has passed yet, unless it's happened in the last 24 hours, which is possible, I suppose. But last I saw, nothing had passed. Um, but that law, what's interesting is I did read about, what that would look like, and that law is going to be designed to preempt a lot of state law. Yet to, we'll wait and see what the law looks like, I suppose, to see if that looks like a good idea. Interesting that again, this is kind of a side issue, but that a Republican administration, traditional Republicanism, giving rights to the states, would say we're going to pass a federal law that's going to preempt state law. But it does perhaps explain why some of the states have not moved in this area. In particular, Florida has not really had any developments in AI law. Of course, there have been some in California. There have been, Texas, Nevada, Illinois. Um, but Congress at the federal level has not passed a comprehensive AI law yet. And so right now we're just looking at the states to try and figure out what can we expect? And so just a little background on some of these different state laws. I don't know if depending on where people are joining us from, it doesn't necessarily apply if you're where I am in Florida, or I also am licensed in Nevada. Some of this does apply there. There's some mental health laws that have been passed in Nevada. But we can expect to see similar laws passed across different states, and maybe the federal law borrowing to some degree from some of the states, because they're looking at a lot of the same issues. And a lot of times when people collaborate on these, they're identifying the same types of issues to figure out how they want to deal with them from a legal and regulatory perspective. In California, law there prohibits AI systems from misleading patients into thinking they're clinical licensed clinicians. Well, that makes a lot of sense, but anybody who's used or dealt with an AI agent, I talked about an agentic AI earlier, if you've dealt with any of these agents, they are becoming more and more human-like, including human voices. In connection with my research on this topic, I came across some regulation related to the telemarketing law, the TCPA telemarketing. I forget what it stands for, but it's the law that basically says that you can't call people on a do not call list, and it puts restrictions on blast faxing, things that go back, 20 years. The laws have been in place. Well, now you've got these agents that are calling people, and if it's not humans, does the law apply? Of course, these agents are working for companies, are working for humans, so the law follows up. Uh, or I should say, clarify that for folks to understand. If you have an agent doing something for you and you're the principal giving instructions to that agent, legally you're going to be responsible for that activity. Uh, but the law still needs to be adjusted because some of these agents are running off and going outside the scope of the instructions that they are given. Uh, in Texas, there's required disclosure whenever AI is used in diagnosis and treatment. I imagine at a certain point this is going to become redundant, because listening to folks in that are practicing in healthcare, when I'm listening about the clinical side and the diagnosis side, the day-to-day practice, both in talking to clients and the stuff that I read and I listen to at an industry level that's not necessarily focused on the legal side. Uh, at some level, you're going to, even if it's just in notes and in relying on those notes at a next visit, pre-authorizations, again, at level or at some point, we're going to be in a situation where AI is always going to apply. So I wonder if these laws that say, hey, you have to disclose whether AI is used in diagnosis or treatment, the better practice, more likely than not, is going to be, or the common practice is going to be, the providers are going to have patients sign something in an informed consent saying, hey, you realize that we rely sometimes on AI. Ultimately, a human's going to be responsible for that decision. I don't think that's going to change, but that's probably going to go into almost every informed consent that a patient signs at a certain point going forward. I would expect even in Florida and my own clients. When that happens, is this another one of those things that just gets glossed over, where today it seems important? Well, we have to disclose this to patients. We have to let them know what's going on. We have to let them know how their data is treated, but everybody just signs it. Nobody really cares. That's the practical reality of this. Is nobody, a lot of times people sign this stuff, they make it a big deal for a short amount of time. But if you want the treatment, you're going to have to sign the consent, or otherwise you're going to have to go find somebody else. And at a certain point, it's almost going to be uh, a deficiency in your practice, and I've heard this concept also raised, that you may, at a certain point, it may be considered negligent or malpractice not to rely on AI or get input from AI when it's available because it's so effective. So you have to have this balance of the AI performance balanced with the human oversight. And just like self-driving cars, are we going to get to a point where you're just going to be able to sleep in the back seat while the car drives down the road? I would love that. I'm not a big fan of driving. I'd love to have my own driver. I don't see that anytime in the next few years. Lots of legal issues that arise from that. Just simply when you're talking about healthcare, if the AI screws up, is that a malpractice question? And then I was listening to somebody talk about malpractice insurance for AI devices or for AI agents or for AI decisions. And apparently there's a company in Utah that started to look at that in issuing insurance coverage for AI decision making tools. Uh, is that a product liability issue? Is it negligence? Is it malpractice? These are all going to be these interesting questions that we don't have all the answers to, but I want folks to be aware of it so you see what's coming and it's you don't hear it for the first time when there's a new law passed. The big picture takeaway from all of this is again, the states are real big on transparency and disclosure and in bias, and we'll talk in a few minutes about about bias. Uh, I wanted to also touch on Nevada again because I am licensed there and I know I share some of this information there. Nevada has passed a pretty comprehensive law dealing with AI mental health tools. Illinois has a similar law, and it restricts the use of AI bots in treatment. I, I, I was thinking about that, in counseling sessions, psychiatry sessions, it's a lot of talking back and forth. And so, setting up an agent, if anybody's spoken with an AI agent, or if you've just brainstormed anything with an AI system like ChatGPT, the most common one, it begins to seem like a discussion. And so some of the states are getting in front of that, saying we're not going to allow you to simply have an AI agent perform counseling sessions because you could see where that model would go. Of course, you'd have set up a team of counselors who are AI, tell people what they want to hear. There's no oversight or limited oversight. They charge for that, and there's no human involvement or human intervention. Again, interesting questions, but the takeaway for the folks today is that you still need human involvement and oversight, and you need disclosure when you're using it. We probably expect to see the same thing at the federal level and in Florida. All right, beyond legislation, we have guidance from healthcare organizations and accrediting bodies, the Joint Commission and Coalition for Healthcare or for Health AI has issued some emerging governance. They have outlined what they've called the seven pillars for safe AI adoption. Right now, these are voluntary, but we can expect that, at a certain point to obtain accreditation, you're probably going to have to go through some approval process where you pass these AI standards. Uh, Examples would include things like oversight committees, validation procedures, ongoing performance reviews of AI, and as it changes over time, and bias monitoring. Um, And then again, I mentioned that there's a federal law in the works as of December, or as of the last that I looked at it. The idea is that it presents a national AI framework that would preempt state rules, or at least preempt them to the extent that they conflict. That may draw some constitutional challenges, I suppose, but we've got to wait and see what that is to make a decision on whether or not. And when that happens, we'll probably do another webinar and talk about it. And if you're interested in something like that, please let me know. Drop something in the chat or shoot me a message, and we'll put it on our radar. Want to go back to some stories that case stories that changed uh, privacy, and I talked about these a little bit early on, so I don't need to spend a lot of this slide there. So spend a lot of time on these, but it gives you an idea of where things can go with AI. So I mentioned the Amazon Echo case, and uh, and this is a case where there was a question of somebody died in someone's house and law enforcement was trying to get information, and there was an Echo device in the house, and they subpoenaed the Echo conversation records. Interestingly, in that case, what never really came out much in the news, but I read a lot about it at the time. There were questions about, how would you use the data that was collected? Could you get it admissible in court? Could How would you authenticate that data? If it was recordings, were the recordings legal? If it's a two-party system where everybody has to be aware of a recording, is it even legal to capture that information and introduce it? Um, all of those, and Amazon was subpoenaed for the information and raised an objection. They raised First Amendment objections. I thought was really interesting that the Echo that they had a First Amendment right to not give up information that was gathered as part of its speech and collection of speech with the individual who was involved. But what flew under the radar in that case, and you can think about how this might apply in the healthcare context. It wasn't the echo data that really it became dispositive. It was the hot water meter. And it turns out that they were able to measure water usage and hot water usage from a water meter. And there was a bunch of water that was used in the middle of the night. And they surmised from that that it was used to clean up blood from what they said was, at the time was a murder. And nobody really talked about that. Everybody focused on the echo. But the fact that you were able to get it just from something as simple as a water meter and that data could be tied into a story to convict somebody or at least charge somebody with murder, you could see how AI systems in healthcare, if you have, again, pacemakers, um, the Fitbit murder that I mentioned, where they showed that somebody was at a different location than what they said they were when they said they weren't involved in a crime. The person who was thought to be involved said they had gone to the gym. But the Fitbit actually showed that they didn't go to the gym. They never had an elevated heart rate. They were able to see from geolocation that they weren't in the place that they said they were at the time. And so looking at this data, folks were able to tell, the investigators were able to tell that the people who were giving the information that conflicted with the AI machines or the AI embedded devices conflicted. You've got, of course, you've got heart monitors, you've got blood pressure, you've got Fitbit devices, you've got blood sugar. And these things, a lot of these physiological symptoms, as healthcare providers know better than I do, can be affected by things like stress, physical exertion, can be affected by, through different times of day, what people eat, what they drink, etc. All of this is foreshadowing the types of stuff that we can see if you start getting asked for information. If you're a provider and you receive a subpoena, how are you going to respond to that? Do you give up the information? Do you have any requirements under HIPAA or state privacy laws to restrict sharing that information with law enforcement? That's something that you have to take on a case-by-case basis and probably consult with your legal counsel on before just simply responding either to a law enforcement subpoena for criminal purposes or to a civil subpoena if somebody subpoenas that information. And I don't know how often that's happening right now that uh, civil litigants are subpoenaing healthcare data, but you could certainly see it, for instance, in family cases where right now or we know that one of the common subpoenas that will go out will be for records of the device that's in your car that tracks when you go through the toll booths and the SunPass device. I know many divorce lawyers who will subpoena SunPass information because that SunPass information can be used to disprove someone's story about where they were traveling to, whether they were having an affair somewhere else. And when you get geolocation data, when you start talking about health data, again, increased heart rate, increased physiological signs. You can see where all of this information could be potentially used in civil lawsuits. What if you get subpoenaed with that as a healthcare provider? What if you get asked for that information? Do you give it up? You have your patient who's the owner of the information. They have a right to share it. But what if that person objects? Now you're sort of caught in the middle between a court subpoena and a patient who's objecting. How do you respond to that? And I don't have good answers for that. I just want you to be aware that these are issues that we're going to have to deal with. Let's see. All right. Oh, so I already talked about some of these systems that are already in healthcare now. Um, and there's others, of course. This isn't a comprehensive or an exhaustive list. Uh, I want to sort of break regulation down into three layers. And I went through slide after slide trying to present this in a way that wasn't going to be overwhelming. So I've redone this a few times. I apologize uh, if I got some typos in here, but I redid it. And I was really trying to break it down in the ways that would be easily digestible. And so the first layer of regulation comes from medical device regulation. This is FDA oversight, software as a medical device, and algorithm change control plans. And I mentioned this earlier. I think I have a slide on it coming up, so I'll come back and touch on it. But essentially, the change of control issue or the change control issue comes up because these medical devices need to change over time. and the device that gets approved by the FDA could be a very different device 6 months later or a year later when you see how fast this stuff is moving. Beyond federal regulation, which is mostly FDA, you see a little bit of FTC. We see uh, additional federal regulation, of course, with privacy and data use. That's HIPAA and state privacy laws. And uh, and then the third layer is professional responsibility, and that's uh, malpractice, licensure standards, and standards of care when it comes to using these in your practice. And the malpractice issue is again going to be really interesting right now. If you are using AI and don't disclose it, that can be an issue that can be raised as a potential negligence if you don't have a patient who has not given informed consent and something goes wrong. There's going to be a certain point, however, I believe that not relying on the best tools and the best information available is going to give rise to claims. And it'll be interesting to see whether the use of AI devices will be incorporated within existing malpractice insurance policies, or whether this will be a separate policy where you will insure the AI device, and whether that will be something akin to malpractice, whether it will be a product insurance, like a commercial liability insurance policy or something for product liability, or if it will be some mix of the two if we create a new invention to insure these devices. All right, here's some updates. This is stuff that I gathered just recently, legal and regulatory updates for 2025 and 2026. I'm going to kind of work through these kind of fast. There's several states, as I mentioned earlier, require disclosure when AI tools are used in patient care. This is things like informing patients when AI contributes to diagnosis or treatment. Some jurisdictions are requiring explicit consent. Again, I have not seen that in Florida. I looked. I would expect we're going to see something maybe at a federal level or Florida, and certainly when it comes to accreditation and incident reporting, that's probably going to be an issue as well. It's all about transparency. It's all about letting folks know. We're seeing that on the legal side too, as well. You see courts now starting to implement administrative orders to say if you use AI in connection with any filings that you make in court, you're going to be required to disclose that. Uh, and it's the same thing. It's all about disclosure and informed consent. A little bit. FDA is sort of in front of a lot of these issues. I did a presentation a few years ago on these wearable devices because the FDA has been trying to regulate these for several years. Um, and and as I mentioned earlier, one of the biggest challenges with AI with the FDA is that the traditional medical devices are static devices. Um, it's such as a pacemaker or an MRI. It works the same way every time you use it. It doesn't retrain on new data and new information, but AI devices do retrain. They refine their predictions. They adjust internal parameters. And the idea is that they're trying to improve accuracy over time, and this creates a regulatory challenge for the FDA. And so traditionally, a medical device would require, and if it was updated, would require a new submission to the FDA. But now, as these models are evolving continuously, the FDA has introduced this concept called predetermined change control plans, or shortened to PCCP. I don't know if I have, yes, I have this on the slide here. And the PCCP is essentially a roadmap that's submitted to the FDA in advanced planning. So you tell it, okay, this is what the device does, as I understand how this works. This is what your device does, and this is what it's expected to do moving forward. This is the predictions that we have for how the device will work. And if the FDA approves the plan, then the developer can can allow the devices to make pre-approved updates overseen by humans without going back to seek new approvals from the device maker. The key takeaway for the providers and the folks that are mostly probably attending our seminar today is that these devices are not static. They're evolving systems. They're going to likely change after deployment. And if you have devices like that, it's probably a good idea to ask for the plan. So you know, because as a provider, one of the overarching themes that we see is that you have a responsibility not only to disclose to your patient population the way you're using these tools in decision making, uh, but you also have an oversight responsibility. If something goes wrong, the legal liability is going to be, and as I see it, at least twofold. It's going to land at the provider in the practice, and it's going to land at the manufacturer. And if you don't understand how these devices are developing and evolving, how they're intended to work, that could put you in a bad situation if you're facing potential liability. Uh, how do you deal with that at a practical level? Uh, I think you need to understand model updates. You need to understand, you don't have to understand necessarily the algorithms, but you need to understand when changes are made. I would say if I was I don't represent manufacturers on these devices, but if I was representing providers, I would want to get some type of assurances in a contract that you're going to get regular updates if the devices are changed, modified, or updated, that you get updates for that. It's easy to write into a contract, by the way. You don't necessarily need to amend a contract every time you do that. We already write that type of language into a lot of uh, software contracts. We put some language in that says whenever there's an update, we're going to notify you of the update. This goes, for instance, terms of service. And if you're using any type of software like an EMR software, if we update our terms of service, we'll give you notice of it. If you have any objection to it, you'll let us know, and you can terminate your agreement within 30 days or whatever the time frame is, or you'll continue under the old version, and then your agreement will term out. Otherwise, the agreement will continue in place with this new device, with the new changes, with the new functionality, and you're deemed to have agreed to those. So it's not difficult to do from a legal perspective. You just have to plan for it. I hope that makes sense to folks. It seems like it's going to be right now. It's a big deal, but it shouldn't be going forward. It sounds a lot more complicated, I think, than it is. HIPAA, privacy issues, data fusion. Um, One of the biggest misconceptions about HIPAA, I think, is that it governs all health data. And the reality is that it does not. And many AI models use data from consumer apps, fitness trackers, pharmacy databases, retail purchase data. There's stories about people, making regular purchases online, and then the purchase years ago, there was a famous, not famous, an infamous, I should say, story about a girl in Minneapolis where the father objected that Target had sent her, it had something to do with pregnant, it was some pregnancy treatment or pregnancy tests or diapers or something. And it was like a 16-year-old girl in high school, and the father went ballistic. And it turns out that the purchasing data and whatever other data that was provided ultimately to Target's decision-making process, Target stores, had predicted that this girl was pregnant. She had not told her father. Of course, 16-year-old girl. Father became upset when this stuff arrived in the mail. It turns out that she was pregnant. So the predictive analysis of simply these retail purchases predicted the health condition of this 16-year-old girl, and started sending her either advertisements for this stuff or sending products to her house or free trials or something. That was a few years ago. So if you haven't had an experience with this or haven't read about any of these, it's really, the level of predictive analysis that these models can perform is sometimes astounding. Well, all that stuff that we just talked about all generally falls outside of HIPAA protections. HIPAA is, narrowly drafted, and it just deals with PHI handled by, the certain, operations and providers and payment sources, or payers. And so anything outside of that model, HIPAA doesn't apply. When HIPAA doesn't apply, then the next issue we're looking at is FTC, state privacy laws. Sometimes states have their own version of a HIPAA type law or medical records privacy law that might be more stringent than HIPAA, and that's allowed. HIPAA will, we talked about federal preemptions. HIPAA will preempt state laws to the extent that they conflict, but state laws are allowed to be more restrictive and have more things that are included within the layer of protection. Of course, HIPAA itself has a certain way written within the regulation or how you can anonymize that data and use the data and sell and transfer the data if you go through a certain exercises to anonymize it. So what happens if the data is not governed by HIPAA? And HIPAA, by the way, doesn't necessarily give, I get calls and we don't represent individuals suing healthcare providers, but I do occasionally we get calls off the internet of people who think that their privacy rights have been violated and they want to file a lawsuit against somebody for breach of HIPAA. And HIPAA doesn't really give you, you can create a private cause of action another way, but HIPAA doesn't give you a private cause of action for violation. Where it would enable you to just rely on the statute and go sue somebody. But the FTC does. And if you violate certain federal protections and certain regulations, like HIPAA or high tech or any state or federal privacy laws, even if there's not a private right of action, the FTC does allow you to bring a claim for unfair and deceptive practices, which would include generally not following federal regulations. So that's how you tie a lot of these claims into, you take claims that might not be covered directly by a statute or a reg, or even information that's not directly within HIPAA, you could still turn it into a claim if you are creative enough and if you rely on something else, such as either a state FTC Act in Florida, we would have the Unfair and Deceptive Trade Practices Act under Chapter 501, or federal law would be the FTC uh, Lanham Act or the FTC's regulations for unfair and deceptive trade. Uh, the challenge here is figuring out when you're in possession of this data or you're controlling the data as a provider is understanding the different regulatory regimes and understanding if you're under HIPAA, it makes it a little bit easy because it's pretty structured regulation. If you're not, you still have responsibilities. This comes back to the question of what if I get subpoenaed? What if somebody asks for this data? I had a situation with a provider client a couple of years ago where somebody had passed away and they were out of state, and then the father had was the personal representative of the estate, and he was trying to get the son's medical records, and it just created this question. We wanted to be cooperative, but it created questions on who's entitled to that information. What do you need? What's required? Do you have to have a subpoena? Do you have to have a court order? Has somebody given already a HIPAA authorization to allow that information to be captured or collected? So just again, be aware that these issues are out there and be careful with it. All right, I mentioned earlier the bias and transparency issues, and I wanted to touch on this a little bit. And this goes, there's this notion of the mosaic theory of data, and this goes back to machine learning, is that you take little points, you take small points, and you can put together a picture, and like a mosaic of somebody's lifestyle, of somebody's habits, of somebody's predict what they will do. And AI models are designed to predict things like mood and risk and health conditions. And we're using that more and more, and it can be very handy and using it to predict health conditions to try and offset bad things that will happen to people as the future arrives and as they get older or if they don't change their lifestyle habits. Some of this is kind of obvious. Some of it is intuitive to healthcare providers. If you told patients to eat better or get more sleep or reduce stress in their life, you know that these things will are certain predictors of bad things that will come. There's the old notion about connecting data and whether it's a cause or effect or whether it's just a correlation, and it has to do with flossing teeth, and people who floss teeth on average live, I think, 7 years longer than people who don't floss teeth. Well, is that because flossing teeth makes you healthier and makes you live longer? Probably not. There's been no cause and effect relationship between the two, but people who floss teeth tend to be more conscientious about their health in general, and those lifestyle habits tend to lead them to live longer in life. So I want to give you this example. In 2019, there was this study on that had to do with bias in health algorithms, and the algorithm had underestimated illness in minority patients. And the reason for that was that it used healthcare spending as a proxy for illness. So essentially, the algorithm said people who spend more on healthcare likely have more illness, more medical conditions. People who spend less have less, and so that it predicted that the folks who spent less had less healthcare issues, healthcare risks. And what we found out from that study was that minority patients in general received a lower risk score despite having equal illness risks. And that's because they tended to spend less on healthcare. Well, simply spending less on healthcare as a predictive model, there may be a correlation there, but there's no cause and effect. And so the lesson from that is that AI bias can come from bad data or from a bad interpretation of data. It's not necessarily the code, it's just they're not connecting the points correctly. It's making a cause and effect and prediction, taking the next step to make a prediction where there's really just a correlation. Why do I bring this up? Why do I mention this? I'm looking at our time, make sure we have time to hit a few more. The reason I mention this is that if you're using these systems and you're relying on these systems, the providers, and we're seeing this from the state law, and I expect to see this in the federal regulation, bias is a big issue in healthcare and in treatment. And what we're going to see is that the providers are going to be responsible for making sure that there's no bias in the system. And if there is bias in the system and it affects somebody, uh, if it affects their health or if it leads to a negative health outcome, you could potentially be responsible for that. So you need to be aware of it, need to be aware of the concept. It's not a fiction, it is real. It's one of the biggest issues that I've seen over in looking at different laws. The overarching themes are disclosure, patient consent, and bias. There's a lot of focus on bias in connection with these healthcare functions. All right, contract terms. This is where this really comes into a lot of legal issues. Um, there are several issues to be addressed whenever you contract for AI systems, or not just AI systems, but systems that rely on the use of AI, maybe to make your life easier. This could be simply record-keeping systems, billing software, medical record software, etc. Key provisions include data ownership, not only data ownership, but also sharing. Who has the ability to use the information? If it's going to be used, if it's going to be transferred, how does that information get anonymized? Making sure that you have, if required, if you're under HIPAA, making sure you have a BAA in place, a business associate agreement, and making sure that it covers that it's up to date. There's a model BAA in the Code of Federal Regulations, the terms that are required to be included, but in addition to the terms that are required to be included, I'm now with clients addressing additional issues that come up with data because it's become such a big deal. So how is that data used, handled, shared, and what happens to it? Like for instance, if a provider goes out of business, or if you're working with somebody and that vendor goes out of business, where does your data end up? You need to understand that. Indemnification for errors or reliance on these tools that do result in bias. So I mentioned it. If you are found to if a patient has a negative outcome because of bias in the system, the provider is going to be liable. Well, will you get indemnified from the company that provided you this system? What's that indemnity look like? And is the company able to back up that indemnity? Not only do you have it in the contract, but is there something or someone going to be around? Is it going to be covered by insurance? Indemnification in these contracts is a big deal. It's a heavily negotiated term in these contracts. And when I look at them for providers who are negotiating with vendors, what I often see is one-way indemnification. You, as the provider, are required to indemnify the manufacturer or the provider or the vendor for anything that you do wrong. And I don't see a mirroring indemnification provision. And we always want to include that, and we're going to try to include it. And here's a takeaway for folks as a practical matter. Most of these most of these contracts that you're signing with vendors, they're negotiable. They give you the contract, and I write these for product and service providers, for vendors, and we do little things. Well, I'll tell you like a little secret. They send it to you in a PDF. I like a two-column agreement. I don't know what it is. For whatever reason, people look at a two-column agreement and they tend to just sign it. They don't negotiate it. They think that it's just a standard form and they're going to sign it. So I often have clients do two-column. But if I have a client signing a contract with a vendor, one of the first things I'll do is I'll ask for a Word copy of the contract. And that will tell me if the vendor, because if you ask for word copy and the vendor or your counterparty in the contract says, hey, we don't do that because we don't change it. Well, now you know. Say, well, we may have some changes. Are you open to those changes? If they're not open to them, now you need to know, do you need that tool that bad, or is this something you're willing to walk away from? I would say probably as a practical matter, 80% of the time, 75 to 80% of the time, the contract might be able to be modified. It may not be modified in the agreement. Sometimes it's just simply adding an addendum with an additional term. And that term might be, hey, if this system screws up, you indemnify me, or you agree, represent and warrant that you have insurance to cover this. And we put that in additional addendum. Sometimes they'll tell you things in the sales pitch. Yeah, we have this and it's been tested here and we have this amount of coverage. Okay, where's that in the agreement? Show it to me. If it's not in the agreement, then let's pull it into the agreement. If they've given you a term sheet or they've given you some pitch or proposal or that's in their advertising or in their website and it's not in the written contract, then we just simply do an addendum that says, hey, the written contract includes and incorporates these other things here that you've represented. Easy way to protect yourself. I highly recommend that you do that or have your legal counsel do that. Um, Contract, I mentioned this earlier, account for model updates, retraining, and termination rights and data portability. What happens to the data when you terminate? Who owns the data? Who controls the data? Who have they shared it with? Can you make them destroy the data if you haven't agreed to allow them to share it? Service level agreements are a big deal as well. How well, what is the response times? What happens if the system falls down? What are your protections? All right. I think we've got just a few minutes left, and I want to kind of, and I apologize here. There's some additional stuff in the notes, but I'm going to probably jump towards a lot of this is just focusing in more detail on what we've been talking about, the human oversight. I mentioned earlier state regulation of mental health AI tools. You can't use agents or bots to provide mental health protection. And what I want to highlight here on the slide that you're looking at is some of these states are implementing fines for violations. So it's not just a law that says you can't do this. If you're found to be in violation of the law, you could be subject to a fine. There's an active investigation right now in Texas. And so there's a push, the tech people want AI to get closer to replacing clinicians. I don't think that's going to happen anytime soon. There's always going to be some level of human oversight, and it's finding the balance between the two on who's going to be responsible when something goes wrong. Uh, More on state regulation of mental health tools. So bringing it full circle, things that we talked about back in 2019, the data, the novelty of AI back in 2019, now it's in our everyday world. We see it all the time. Um, and data is still the central issue. There's privacy expectations that are shrinking because people realize they have to share information and agree to share information if they want to get the benefits of this. But now the surprise really isn't from the regulatory organizations. It's really from the private sector and how much they're collecting and using data to make predictive analysis. Practical strategies. This is the stuff you want. You need to inventory your AI systems, understand what you have. Review your vendor contracts. Make sure that there's some indemnity. Make sure there's insurance. Find out what they're doing with your data. Find out um, how updates are made and how you're made aware of updates and make sure that you're using stuff that's approved. Um, you need to make sure that people who are using this stuff are trained on oversight, proper documentation, have an audit system for bias, or ask for reports. Anybody who's bringing this information to market now should have reports to show how it's been tested against bias. Of course, track regulatory updates regularly. And here's two key questions to keep in mind. First is what data trained the AI model that you're using? And the second is who owns the data that the system generates? And you need to understand who the owner is of the data and who controls it. Um, with that, I'll leave you with sort of the final issue, which is what I call the privacy paradox that I talked about in 2019. That the great convenience comes with a Faustian bargain of diminished privacy expectations. Today in healthcare, patients want AI's benefit with a faster diagnosis, better predictions, but they rarely understand the data trade-offs behind it. And it's your responsibility to make sure that they understand those trade-offs, even if it's not even if they just agree to it, you need to have it in some type of informed consent or have it documented. And so, the question for today or the closing thoughts for today are, not how we're going to deal with this AI once it arrives in healthcare. It's here already. It's how do we govern it and use it properly going forward and make sure that everybody that you're working with understands it. That's my wrap up for today. Sorry, we went over by about a minute. If you have any questions, I'm happy to stick around and field those, or you can email them to me. I'm looking at the chat. You can find me on LinkedIn, find me by email, Bowman at fbl-law.com as on the screen. Thank you, everybody, and have a great rest of your day.